All right, Miss Interpreter, it looks like there's no Spanish cases for you today, so have a good day.
You too. Thank you so much.
Bye-bye.
Bye.
Mr. Heydrich?
Morning.
Good morning. I didn't know if you saw in the packet that they had that bail modification on Mr. Roy.
On his review hearing?
It was a pre-sentence case that because he got a new case, so they put a bail modification in there, asking for revocation.
Oh, is that the battery?
Yes, I did add that case for this morning, just so you are aware.
Perfect. Thank you.
You're welcome. All right, I will let the jail in.
Good morning. Are we ready to proceed?
We are here, Your Honor.
Good morning, Your Honor. Yes, the state is prepared.
Good morning. We're here today for the in-custody arraignment calendar. Today is January 17th. Are there any special requests for continuances or requests regarding the order of the proceedings before we begin?
None here at the jail, Your Honor.
Your Honor, I apologize. I'm reading a investigator note. Your Honor, we were waiting for victim contact on Mr. Mealer. We still have not arranged that, so I have no special requests.
Thank you. We'll go ahead and call our first matter today, which is Tanner Mallow, followed by Dustin Perry.
Thank you. And with regard to Mr. Mallow, he is waiving his personal appearance today and prepared to proceed in his absence.
Thank you. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent him. I am in receipt of the Nevada pretrial risk assessment, which indicates that he scored as an 8 or a moderate risk utilizing that tool. State, are we ready to proceed with the bail hearing?
Yes, Your Honor, we're requesting bail in the amount of $5,000 bondable with no additional conditions. Mr. Mallow does score that 6 on the pretrial risk assessment, and his most recent criminal history is that misdemeanor theft out of this court, which he was sentenced on this year. Outside of that, his only other criminal history was the failure to obey order of a juvenile court in 2022 out of California. Does look like he has that juvenile hold. Your Honor, this, given the likelihood of conviction in this case, we do believe some monetary bail is appropriate.
Thank you, defense.
Thank you, Your Honor. Your Honor, we would submit to that bail, but ask that it be interim. In reviewing the sheet for today, it appears that a co-defendant in that PC sheet, Mr. Carrillo, was ultimately not found to have PC for his hearing today. Given the question about the PC using the same sheet and same alleged incidents, I would ask that this one be just set interim so that we can review it when we've got some more information. Absent that, at this time, he is on sentence through the end of February.
Thank you. Based on the information provided, I don't think that there's a legal basis for an interim bail. So with just that in mind, I appreciate the information. However, it will be, as we are doing the Valdez minutes here today, it will be bail as imposed, just to make sure that is clear. So with respect to the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. I will note that the defendant is currently in custody while this crime is alleged to have occurred. Additionally, the violence is described and the likelihood of conviction, the court does find that bail is appropriate in the amount of $5,000 bondable with no 10% cash option. Based off of the request of the state, there will be no additional conditions, so no supervision requirement as part of this. We will go ahead and set a 72-hour hearing. And Madam Clerk, when will that 72-hour hearing be?
That date will be January 23rd.
Thank you. Next, we have Dustin Perry, followed by Paul Akfal.
And Your Honor, Mr. Perry is not present in the courtroom today. The basis for his absence is one of inability to communicate efficiently due to mental health concerns. We would therefore ask that this be interim bail since he has not had a meaningful opportunity to speak with counsel, and we would likely be filing an SB 89.
Thank you. State,
$2,500 bondable, please, Your Honor.
any conditions?
I would say pretrial supervision with no controlled substances, given the effects of the weed gummies as noted in the probable cause sheet.
Thank you. The court will be imposing the interim bail in this case. It will be in the amount of $2,500 bondable with a 10% cash option. Just to make sure that is clear, that is an interim bail. If the defendant is able to post that bail amount, I will require that the defendant be subjected to pretrial supervision, and so must check in with pretrial services within 1 business day of release, and impose the condition that the defendant is to have no controlled substances or alcohol unless there is a valid prescription. I did not hear a request for testing, so testing will not be required. And we will go ahead and set that 72-hour hearing. And Madam Clerk, will that also be for January 23rd at 9:30 a.m.?
Yes.
Thank you. Next, we have Paul Akfal, followed by Aziz Ferraro.
Thank you so much, Your Honor.
Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 6 or a moderate risk, which was overridden to a higher risk utilizing that tool. State, you're ready to proceed with the bail hearing.
Yes, Your Honor. So in this case, the state is going to seek bail in the amount of $5,000 bondable. Pretrial supervision I don't believe there's sufficient nexus for drug and alcohol testing, but we would ask for a no weapons clause. As noted, Mr. Akfal does score 6 on the risk assessment. Most recently, his criminal history includes a contempt arrest with no disposition last year, as well as a felony conviction for violating a condition of release, misdemeanor drug paraphernalia, and misdemeanor contempt. Those are all out of Carson. Prior to that, in 2022, he had an attempted possession of stolen property out of this court misdemeanor conviction. Given the facts of this case, we do believe that he presents an ongoing risk of further criminal activity and risk to the community. So we do believe bail and conditions as noted to be the least restrictive means.
Thank you, defense.
Thank you, Your Honor. Your Honor, I don't believe the state has met its burden to show by clear and convincing evidence that monetary bail is required. According to the PC sheet, this all stems from a October 22nd incident. He's been able to be found by law enforcement. The PC sheet noted the fairly extensive investigation into this matter. He has been available for officers and in fact was the one injured. We have no objection to the causes of no substance abuse, no weapons clause if he is released, but I don't think that they've shown, given the 6, which is the moderate risk, the lack of felony history and the lack of FTA convictions, that checking in enhanced pretrials, well, not enhanced pretrial services anymore, but that alternate services would not meet the needs of the community, especially with that NPRA. He was at the hospital when he made that report with a head injury. I think that that can be taken into account. With all of that in mind, I don't think the state has met that burden under Valdez-Jimenez, and therefore I don't believe that this court can impose a monetary bail when alternate means exist.
Thank you. The court does find that there are least restrictive means that can be imposed in order to ensure the safety of the community. So the defendant will be given an own recognizance release here today. I will require that you check in with pretrial services, and just for the record, that'll be for monitoring, not for supervision. So you will be required to be monitored by pretrial services. So you must check in with pretrial services within 1 business day of release. And you are also ordered to have no firearms or weapons. I do find that there's a sufficient nexus given the allegations to require that to occur. Additionally, we will go ahead and set your arraignment, which will be set for February 4th. At 9 a.m. You must appear in Reno Justice Court on that date and time, as well as comply with all these conditions, or else a bench warrant will be issued for your arrest. Thank you.
Thank you.
Court's indulgence, just one moment, please.
Thank you. Next, we have Isis Farrow, followed by Stephanie Bennington. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a moderate risk utilizing that tool. And just for the record, that was a 5. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Given the facts of this case and the amount of narcotics located, we are not objecting to Ms. Farrow's release in this case. We are requesting she be supervised by pretrial supervision. And as this was a drug case, we are requesting she have testing for controlled substances.
Do you have any information about that Reno Municipal Court case that was referenced?
Your Honor, I apologize. I did not have time to look into it today, given the length of the calendar, but I'm happy to look it up at the moment if you'd like.
And Your Honor, it's my understanding that there was a $3,000 bondable bail set on that. Our office was able to reach out to Matthew Campbell, Ms. Farrow's son, who I believe is also participating as a viewer of this hearing. It's my understanding that they are prepared to bail Ms. Farrow out on that. She has already spoken with her I'm so sorry, Your Honor, her sponsor through peer support groups. They are already planning a 30 and 30 together. The plan was to get her out on that, get her treatment. She does want the testing, and we have confirmed through Mr. Campbell that she does have a place to live with him, that she was employed. She's been at Subway for about 3 weeks, that she is going to continue her journey on gaining sobriety. She is doing school and qualifies through SSDI. So I believe that there are appropriate alternatives to monetary bail. And as to the misdemeanor Reno Muni case, they do have a plan in place.
Thank you, Ms. Meyer. My question with respect to the Reno Municipal Court is whether or not she's being tested as that and being supervised. And in essence, if I would be adding another layer of supervision that's not necessary.
I apologize, court.
Do you have that information?
Being tested, but I'm happy to be. She is not being tested. She reports, but is happy to be. There wasn't a nexus there.
Thank you. I do appreciate that. As that was just a concern of I don't want there to be issues regarding being tested through two separate agencies. So just for the record, given the facts as presented, I do find that there are least restrictive means that can be imposed in order to ensure the safety of the community. So you will be granted an own recognizance release here today. You will be required to be supervised by pretrial services, and you must check in with pretrial services within 1 business day of release. I am entering an order requiring that you cannot use any controlled substances or alcohol or medication unless you have a valid prescription be subjected to random drug and alcohol testing. I do find that there's a sufficient nexus to require for that to occur based off of the allegations. Additionally, I am requiring that you complete 3 mutual support groups. So those are AA, meetings or those non-secular versions per week until you are in substance use treatment, and you must provide that information to pretrial services.
Okay.
I will require that you appear for your arraignment, which will be set for February 4th at 9 a.m. So you must appear in Reno Justice Court on that date and time and comply with these conditions, or else a bench warrant will be issued for your arrest. Thank you.
Thank you. Right, oh, yep, go around.
Thank you, Stephanie Bennington, followed by Felix Carrasco Alvarez. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a higher risk utilizing that tool or a 10 utilizing that. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. I would note the state is seeking bail in the amount of $2,500 bondable in this case, pretrial supervision with testing for controlled substances if Ms. Bennington does post that amount. As noted, she does score that 10 on the risk assessment with the pending case out of the Reno Municipal Court. I would also note that risk score reflects a 0 for prior failure to appears. However, it looks like she was arrested on a failure to appear warrant in this case. Prior to this arrest in 2022, her most recent criminal history includes a felony conviction for obtaining or using an ID to avoid arrest. That was locally in CR 22-1632. The PSI from that case notes that Ms. Bennington has 12 prior felony convictions before that felony and 3 misdemeanor convictions. And out of those, her parole and probation had been revoked 13 times. Looking at only those prior felony convictions, in 2020, she had a felony conviction for possession of a controlled substance and a separate conviction for felon in possession of a firearm. She had a felony conviction in 2017 for obtaining or using an ID of another. A 2015 use another's information or ID to obtain credit. As well, that year, she also had a similar use another's ID to obtain credit conviction. In 2007, she had an evading or reckless driving, as well as a hit and run with injury. In 2004, she had a taking a vehicle without consent. 2002, grand theft. 2001, taking a vehicle without consent. And in 2000, she had another felony possession of a controlled substance conviction, as well as receiving known or stolen property. Given that continued criminal history, Your Honor, the high risk score, we do believe some monetary bail to be the least restrictive means with the supervision and testing if she does post.
Thank you. Defense?
Thank you. Your Honor, I believe the state has shown that monetary bail may be justified. I would ask the court to consider the alternative, however, of allowing her to do the AANA or non-religious peer support group, as well as do the check-ins and testing. I think that's appropriate in this case. However, I do point out in the PC that the amount is unclear, but it seemed to be a limited amount in a bag in a communal space with another individual in the car, thus raising question about the proof likelihood. As well, we spoke with her, Miss Bennington's former boss and present friend, who indicated that he could stay with her on Santa Maria Drive. He's willing to help her out moving back and forth between court. He understands that she does need testing for alcohol, he believes is the primary concern. He also wanted us to address that there was a recent traumatic event which I would ask not to disclose, but a recent traumatic event in which Miss Bennington was victimized that may have led to a relapse after being successful through parole. With that in mind, I believe that while the court is entitled to consider monetary bail in this case under Valdez-Jimenez, it does not require it, even though there may be clear and convincing proof. There is an alternative for that checking in and the requiring of the substance abuse peer support groups as well as testing. That's what we would request in this case,
Thank you,
especially
Ms.
given the low amounts.
Thank you, and my apologies. And Ms. Meyer, do you have any, I just want to make sure that I heard you correctly, do you have any information that you were able to verify that the defendant successfully completed parole?
That was information I received through Ms. Bennington. I did not go back and again,
Thank you.
the course calendar.
Thank you. With respect to the information provided based on the facts as presented, the Nevada pretrial risk assessment and NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case, as there are no least restrictive means that can be imposed in order to ensure the safety of the community. And I'll just note for the record the issues concerning the failure to appear, the history of non-compliance. With that in mind, bail will be sent amount of $2,000, $500. That'll be bondable with a 10% cash option. If the defendant is able to post that bail amount, you will be required to be supervised by pretrial services and must check in with pretrial services within 1 business day of release. You are required to not use any controlled substances or alcohol or medication unless you have a valid prescription. I do find that there's a sufficient nexus to require random testing in this case based off of the allegations as well as your criminal history. That will be the order of the court, and we will go ahead and set that 72-hour hearing, which will be set for January 23rd at 9:30 a.m. Thank you.
Thank you. Can you call?
Mr.
Next.
Campbell, you're free to log off.
Can you call him? I can ask my investigator if she has time. Thank you.
Thank you. Next, we have Felix Carrasco Alvarez, filed by Joseph Castleberry. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 6 or a moderate risk utilizing that tool. State, are you ready to proceed with your bail hearing?
Yes, Your Honor. In this case, the state is not going to object to Mr. Carrasco Alvarez's release. He does score a 6 on the criminal history and has no documented criminal history or contact with law enforcement. I would ask that conditions include pretrial supervision and a no contact with the listed Quail Meadows apartment address. I don't believe the probable cause sheet actually provided an address for those apartments, Your Honor. But given the facts of this case, we do believe that there are least restrictive means with those noted conditions.
Thank you. So just state, what is the request for this no contact orders? I would need to include some information as to an address.
I think the Quail Meadows apartment is all the information we have at this time, Your Honor. Actually, let me just try a quick Google search. That may give me an address.
And Your Honor, we do have that address.
Is that the 5599 Quail Manor Court?
Apartment, either I or 146, yeah.
Thank you, Your Honor. That would be my request.
Thank you, defense.
Thank you, Your Honor. We would agree with all of those stated conditions. I do want to note that we would request the potential of a law officer standby for the purpose of obtaining property if there is any. Mr. Carrasco is working at Tesla. He needs to get back there. He does have a place to live with his dad. We were able to confirm that, but he might need either keys or personal identification or clothes for his ability to go back to work. So we would just ask that he have that 1 hour officer standby.
Thank you. So just for the record, if the defendant wishes to utilize that, he just needs to arrange for that. So
Perfect.
just for the record, I am granting an unrecognizance release. I do find that there are least restrictive means that can be imposed in order to ensure the safety of the community. I will require that you be monitored by pretrial services. So just for the record, it'll be monitoring only, not supervision from pretrial services. You will be required to check in with pretrial services within 1 business day of release. You are ordered to have a no contact with that apartment complex as discussed and must stay 100 feet away. That will be the order of the court, and we will go ahead and set your arraignment, which will be set for February 4th at 9 a.m. Thank you.
Thank you.
Joseph Castleberry, followed by Evelyn DeRico. Good morning, sir. We're here today for a first appearance bail hearing. The information that you provided is that, just for the record, probable cause has been found, that you had already retained private counsel. So based off of that information, we have already reached out to your counsel, and your counsel is not present here today. We will go ahead and continue the bail hearing for one day until tomorrow at 9:30 a.m. for your attorney to appear. Thank you. Evelyn DeRico, followed by George Joyner. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a low risk or a 4 utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor, we're not objecting to Ms. DeRico's release in this case. She does have that low risk score. Given the facts of this case and the charges, we believe there are least restrictive means. We'd ask that she be supervised by pretrial supervision and tested for alcohol.
Defense?
No objection.
Thank you. The court does not find that there's sufficient facts to warrant all of those requirements. Is this, just for the record, also is a misdemeanor? So with respect to the information provided, the court will be granting an own recognizance release here today. I will require that the defendant check in with Reno Justice Court within 1 business day of release. You are also required to conduct what we call the DUI rant, and that will be required to be done with pretrial services. We will go ahead and set a arraignment, and that will be set for February 4th at 9:30 a.m. Thank you.
Judge, do you want Reno Justice Court to do the DUI rant, not pretrial services?
That is my understanding, that at this time it has to be done through Reno Justice Court.
Okay, just wanted to make sure. Thank you.
Thank you. Next, we have George Joyner.
Only condition
Correct.
is just the rant. Thank you.
And Reno Justice Court supervision.
Thank you.
Yes.
Thank you. Next, we have George Joyner, followed by Lori Shadrick. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which was an 8, which was overridden to a higher risk utilizing that tool. State, are you ready to proceed?
Yes, Your Honor. In this case, the state is seeking bail in the amount of $2,500 bondable, pretrial supervision with testing for controlled substances, and a no driving without proper documentation clause. Mr. Joyner does score that 8 on the risk assessment as noted. His most recent criminal history is a felony conviction for possession of stolen property out of the 10th Judicial District Court in 2022. In 2018, he had a felony conviction for non-support of spouse or child, also out of the 10th Judicial. He had failure to appear arrests in 2017 and 2015, and misdemeanor history going back to 2006. Most notably, he had a contempt conviction and felon in 2008, a marijuana possession in 2009, and a domestic battery in 2007. I would also note in 2006, he had a misdemeanor conviction for operating while intoxicated. I believe that to be similar to a DUI, but it was unclear out of, I believe that's Michigan. So given that continued history of controlled substance use, we do believe that some monetary bail is appropriate in this case. We would ask that the bailing conditions as requested be imposed.
Thank you, defense.
Thank you, Your Honor. Your Honor, we would ask, while we understand the state's basis on the criminal history, we would ask that Mr. Joyner be able to be released with monitoring by pretrial services, with the meetings of peer support, at least until he is in a substance abuse treatment program. He understands that he does need a program like that, but his dog is out there. His tools are out there that he has taken a long time to get together. Those are how he puts food in his mouth and a roof over his head. He was working on a car and was in a position where he didn't know what was in the vehicle. He doesn't have a phone with him, but confirms that he has a place to live with Michael Pinsky. We were unable to reach him this morning. However, if he could check in and provide an address to pretrial services within 24 hours, he just wants to get out and take care of his dogs and his tools and get working on treatment. I understand the history that he brings, but that would be his request at this time.
Thank you. The court does find that there are least restrictive means that can be imposed in order to ensure the safety of the community. So, sir, you will be given an own recognizance release here today. You are required to be supervised by pretrial services, and you must check in with pretrial services within 1 business day of release. You are ordered to not use any controlled substances or alcohol unless you have a valid prescription and be subjected to random drug and alcohol testing. That will be the order of the court, and I will require that you appear for your arraignment, which will be set for February 4th at 9:30 a.m. Just for the record, I'm also imposing the condition that you cannot drive without having valid documentation, and that is due to community safety. Thank you. Thank you. Next, we have Lon Shadrick, followed by Julius Lugo. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 6, which was overridden to a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. In this case, the state is seeking bail in the amount of $25,000. If Mr. Shadrick does post that amount, we're asking for pretrial supervision with testing for drugs and alcohol, as well as a no driving without proper documentation clause. That is given the likelihood of conviction in this case, the multiple packages, some of which were labeled with the price of the narcotics within them. This is fentanyl that Mr. Shadrick is accused of selling. While he does score 6 on the criminal history and he does have limited criminal history, or excuse me, 6 on the risk assessment and has limited criminal history, which includes a misdemeanor battery from 2005 and a distant DUI, we believe the likelihood of conviction in this high warrants some monetary bail and the fact that this is fentanyl that Mr. Shadrick is selling within the community. So we do believe he presents an ongoing risk of further criminal activity and risk to the community. And we believe bail to be the least restrictive means.
Thank you, defense.
Thank you, Your Honor. I don't believe that establishes the clear and convincing in this case that criminal history is remote. I understand the PC sheet. However, looking at the NPRA, my understanding is that the NPRA is validated to be, I think, 92% likelihood of reappearance and compliance with court orders with a moderate risk score. I believe Judge Pearson gave me that statistic. We further were able to find his additional reference. That reference was a gentleman named Troy who would provide a residence for him to live at Laurel Court. They have been friends for the last 5 years. Mr. Shadrick has been in the area for 5 years. Given the references said that there was no number to reach, we were able to confirm through a telephone number through Troy what his telephone number is and that he did have a residency. I believe that would take him down to the low risk. Given the totality with that validated NPRA score and the remote criminal history, I don't believe that overcomes to the clear and convincing, and therefore we would ask for an OR release with pretrial monitoring. I believe that testing would be appropriate given the allegations in this case.
Thank you. The court does find that there are least restrictive means that can be imposed in order to ensure the safety of the community. So, sir, you will be granted an own recognizance release here today. You will be required to be supervised by pretrial services, and you must check in with pretrial services within 1 business day of release. You are required to not use any controlled substances or alcohol unless you have a valid prescription and be subjected to random drug and alcohol testing. I do find that there's a sufficient nexus based off of the allegations as well as the criminal history. I am requiring that you complete 3 mutual support groups per week until you are in treatment and substance use treatment. I do find that that is necessary in order to ensure the safety of the community. Additionally, I am requiring that you cannot drive unless you have valid documentation, and that is due to community safety as well. That will be the order of the court, and we'll go ahead and set a 72-hour hearing, which will be set for February 4th at 9 a.m. Thank you. Thank you. Next, we have Julius Lugo, followed by Royce Rowe. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 14 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor, we're seeking bail in the amount of $30,000 bondable in this case. That is given the likelihood of conviction. Law enforcement did find the concealed firearm on Mr. Lugo's person. He is a convicted felon, and he does have that high risk score of a 14, noting the pending case out of the Reno Municipal Court. His most recent criminal history includes a misdemeanor possession of stolen property out of this court, as well as another carrying a concealed weapon felony conviction in 2022 in case CR 21302. Prior to that, in 2018, he had a felony conviction for probation violation out of Carson City and 4 misdemeanor convictions for probation violations, also out of Carson. In 2017, he had another probation violation, misdemeanor conviction, as well as a drugs not to be introduced to interstate commerce, a misdemeanor petty larceny, and misdemeanor domestic battery convictions. And then in 2016, he had a misdemeanor drug paraphernalia, trespassing, and obstructing convictions out of the Reno Municipal Court. So given that continued criminal conduct, the prior similar offense, and the likelihood of conviction, we do believe bail to be the least restrictive means. If he is able to post that amount, we'd ask for pretrial supervision.
Thank you.
Thank you, Your Honor. Your Honor, we do believe that the state has met its burden to provide clear and convincing evidence that monetary bail is necessary. However, the amount of $30,000 given the PC sheet and the alleged facts in this case seems an excessive amount. We would ask that the bail be set at $10,000 or 10% bondable with bondable with a 10% cash option. I recognize that the CCW, the ex-felon, I believe, is a category B, but it is not an interpersonal crime. Therefore, we would ask that this court preserve that 10% cash option. We did speak with his sister, Savangelina. I noted in the NPRA that it said that the reference was not able to confirm the information. I'm not sure if that was the same number that they used, but we were able to find a residence on Evelyn Way, apartment 25, that he could live in. He would be welcome back there. He was not working at the time. However, she did know he was searching for work and confirmed that he does have a working cell phone number. Given that he does have residence in the community, I understand with that higher NPRA score and the repeat nature of the charge from prior convictions, this court does need to set monetary bail. We would ask just that it be at that $10,000 with the 10% cash option.
Thank you.
Yeah.
And just for, go ahead.
My apologies. May I make argument as to the 10% cash option?
No need. This court is very familiar with the administrative order, and I'll just note that that is before the most recent administrative order. So I will just note for the record, and my question with respect to the defense was with the Nevada pretrial risk assessment of, were you able to verify that he had been living at that residence for more than 6 months?
Living there about a year. Welcome back if released are the notes that I have.
Thank you. So with that information in mind, just for the record, the Nevada pretrial risk assessment would be an 11, which is still a higher risk utilizing that tool. But I just want to make sure that was clear for the record. The court does find that bail is necessary in this case in order to ensure the safety of the community. So bail will be set in the amount of $20,000. That will be bondable with no 10% cash option. I do find that that is necessary and that amount is appropriate given the facts and circumstances of the alleged, the allegations involving potential harm to this community. The state has met its burden for clear and convincing evidence regarding a threat and harm to the community. I'll note also the history of noncompliance, the likelihood of conviction, as well as the history of a similar offense. That will be the order of the court. The court will require that if the defendant is able to post that bail amount, sir, you will be required to be supervised by pretrial services and must check in within 1 business day of release. I am also imposing the condition that you cannot possess any firearms or weapons based off of your criminal history. I do find that is necessary in order to ensure the safety of the community. We will go ahead and set a 72-hour hearing, and that will be set for January 23rd at 9:30 a.m. Thank you.
I know how dense our calendar is. May I just have 1 minute, Your Honor?
Yes, you may.
Thank you so much. Thank you.
Thank you,
Thank you, Your Honor.
Royce Rowe, followed by Jade Wagner. Good morning. We are here today for two separate matters. The first is an OR bail revocation hearing. The second is for a new case. Probable cause has been found, and the public defender's office has not been appointed to represent you in that case. However, given that you are currently being represented by the public defender in your other matter, I am appointing the Washoe County Public Defender's Office to represent you. I am also in receipt of the Nevada pretrial risk assessment. And just for the record, give me just one moment. That is a higher risk utilizing that tool, or a 9. State, please proceed when you are ready with requests.
Thank you, Your Honor. Given the underlying case ending in 559, we are seeking Mr. Rowe's revocation of his OR release, and we are asking that bail be imposed in the amount of $2,500 bondable. The basis for that, Your Honor, is the underlying offense in that case did involve a driving offense, or started out as a driving offense where Mr. Rowe almost struck the individuals in the crosswalk. Given the new allegations of him speeding, doing 53 miles per hour in a school zone, we do believe Mr. Rowe presents an ongoing risk to the community and risk of further criminal activity as he is driving without any supporting documentation. So, Your Honor, in the new case, we are asking that bail be imposed in the amount of $2,500 bondable for a total of $5,000 bondable between his two cases. We are also asking that he have supervision. I will defer to the court and what level that be, and have a no driving clause.
Thank you. I'll just note for the record that in his prior case, he was not under any supervision requirement.
Thank you, Your Honor. So I would ask that pretrial supervision be included. And I do apologize, Your Honor. I did want to address his criminal history with that risk score of a 9. He does have a misdemeanor arrest, or the misdemeanor pending in this court. Prior to that, he was arrested on felony child abuse causing substantial bodily harm. That case was dismissed after the child did not appear to testify. In 2023, he had a trespassing conviction, a 2020 misdemeanor battery conviction, and a domestic violence 2010 misdemeanor conviction out of Sparks Municipal Court, and another misdemeanor battery conviction in 2006, which does show the continued violence in Mr. Rowe's history.
Thank you. And State, just for the record, how is it appropriate to be addressing the OR request here today, as it was from pretrial services and he was not under any supervision requirement?
Your Honor, I didn't see that he... I wasn't aware that he wasn't supervised at all. I'm not sure why they submitted a report at all in this case if they're not supervising him.
Thank you. Defense?
Thank you, Your Honor. Your Honor has addressed my first concern, which is on that prior case. I'm going to call it the 25 case. It is my understanding that Mr. Rowe was present at court for trial setting on 1/8/2026, that there had been no violations at that point as there was no supervision. It appeared in my limited research that pretrial submitted a violation based only on the incurrence of a new of this new charge. So I'm not certain why pretrial sent in that violation report, but I would suggest that the reports from 1/8 indicate that he was present. There were no concerns about his pretrial compliance at that time, and there were no reports of supervision. On this case, I understand the driving pattern continues to be an issue. However, he scored a 9 on that NPRA. We were able to verify through his sister that she lived at Gypsum Road. It appears that he could live with his mother. It appears that he was not living, so the points are appropriate, but he also could live with his mother at a country circle. So he's got 2 residents where he would be able to go. He was working DoorDash and trying to make money. It's my understanding that a very significant change in his financial status occurred based on the arrest in 2025. That has thrown him into a tailspin. There are a number of studies that say that that can happen. I believe that by that within 72 hours, changes in residency and employment, as well as a loss of possessions at the time of arrest, can, for those in a liminal place of economic security, throw them into a tailspin. I believe that that did happen. I think it would be therefore more dangerous to the community to put him in that tailspin. When he was coming to court, I did look back over his appearances in the other case. He's never missed court. He's been in regular communication. It is not clear that if this court were to impose monitoring with pretrial services, he would not comply with the monitoring, and that monitoring could include the threat of driving. And therefore, as this court has done several times today, this court could impose the restrictions on driving and have that monitored through pretrial. So with that, I believe that there are least restrictive appropriate means. I would ask that he be alerted with those in place.
Thank you. In RCR 2025-132559, the court is going to reinstate you, sir, on your own recognizance release. All previously ordered conditions shall remain, to include the no contact order with the named victims. State, are you requesting that pursuant to statute?
No, Your Honor.
Okay, I'm going to remove that just for the record of, and so Madam Clerk, if that information is still in POPs, we are going to remove that. Additionally, I am requiring that you cannot possess any firearms or weapons, as that was already what was previously ordered. I am going to require that you be supervised by the Reno Justice Court, and so you will be required to check in with Reno Justice Court within 1 business day of release, and you are ordered to not drive unless you have valid documentation, and that is due to community safety. In the new matter, I do find that there are least restrictive means that can be imposed in order to ensure the safety of the community. So you will be released on your own recognizance. You will be required to be supervised at Reno Justice Court and must check in within 1 business day of release at Reno Justice Court. And you are also to not drive unless you have valid documentation. So I just want to make sure it's very clear for you, if this court finds out that you were driving while you are not legally permitted to, it is very likely that you will be remanded and required to remain in custody until these cases are finished. Do you understand?
Yes, ma'am.
We will go ahead and set your arraignment for that new matter, and that will be set for February 4th at 9:30 a.m. Sorry, at 9 a.m. And with that pending case, Madam Clerk, I believe that we have trial set in that case. Is that correct?
That is correct.
And we'll just go ahead and that will remain on calendar. So make sure to make that next appearance. And just for the record, I believe that is set for February 9th at 9 a.m. Thank you.
Thank you.
Thank you, Your Honor.
Go to court on Tuesday. Next, we have Jade Wagner, followed by Sean Weeks. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 12 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. In this case, so, Your Honor, the main concern here is when law enforcement puts that the total weight of controlled substances is 47.1 grams gross weight, but charges this as the category E felony. It's unclear for the state what the total amount will be. Miss Wagner does score high on the risk assessment. She did indicate to law enforcement that she had a small amount of narcotics in the vehicle. So we do believe that at least possession is proven. And with that high risk score, we do believe that some monetary bail is appropriate. She does have a significant criminal history. Most recently, she had the pending case before this court where she failed to appear for preliminary hearing, which does show that she is a risk of flight and non-appearance. Prior to that, she had a drugs not to be introduced into interstate commerce out of Las Vegas in 2021, an attempted possession of a stolen motor vehicle felony conviction out of Las Vegas in 2020, drug paraphernalia conviction in 2019, a felony conviction for possession of credit card of another out of California in 2017, a felony grand theft in 2016 out of California, a 2012 burglary and get or use credit of another out of California, both felonies, a 2011 possession of a controlled substance misdemeanor out of California, and a 2010 felony conviction for grand theft out of California, as well as noted juvenile history prior. Given the prior failure to appear at preliminary hearing and the substances in this case, we do believe bail is appropriate in the amount of $2,500 bondable, pretrial supervision with testing for controlled substances if she does post.
Thank you. I just want to make sure that I heard you correctly. So 2,500, is that correct?
That is correct, Your Honor.
Thank you. And bondable with the 10% cash option?
I would object to the 10% cash option, but Your Honor, I would submit on the rest.
Thank you. Defense?
Thank you, Your Honor. Your Honor, we would ask that the 10% cash option be there. We would also ask in the alternative that there be an IAP to inpatient. Ms. Wagner indicates that she has been speaking with Lisa Moore from Life Changes, that they're looking at getting her a bed there. I believe that that is important, as established by the record, as articulated by the court. We were also able to speak with Abby Cutler, who confirmed that she has been in communication with, that Ms. Wagner has been in communication with Lisa, that this is the most appropriate place for her to be. Given the history as recited by the state, I believe that that would be an appropriate alternative. In order to accomplish that and to be able to hold the bed, that 10% cash option gives her a chance. Otherwise, even that 2,500 is going to be outside her ability to make and at the same time retain that bed. We do understand that Ms. Wagner has another open case. I've let the APD, the Alternative Public Defender's Office, know that this came forward today. It is my understanding that that is set for Tuesday, and I'll be in communication with them regarding the decision by this court today.
Thank you. And Ms. Meyer, do you have information? What I had last heard was Life Changes was not an inpatient treatment program. Do you have information that is indicating that it now is? It was a transitional living facility to the last of this court's information.
Yes, it's still TL, but I believe that they have some beds.
Okay. Thank you.
Thank you.
Based on the facts as presented, I do find that the state has met its burden in accordance also with the facts in the Nevada Pretrial Risk Assessment and NRS 178.4853 and NRS 178.498. The court does find that bail is necessary in order to ensure the safety of the community and the appearance of the defendant. I will note the prior failure to appear. The prior criminal history has discussed the lack of ties to this community as well as the significant criminal history. Bail will be set in the amount requested by the state of $2,500. That will be bondable with a 10% cash option. At this point, the court cannot find that there are least restrictive means. I have considered whether or not a direct transport to a treatment facility is appropriate. However, the court needs more information to determine what the appropriate treatment facility would be and if that is able to mitigate the risk of the failure to appear. So at this time, the court is unable to make that assessment, as I just don't have enough information to find that that is a least restrictive mean. That if the defendant is able to post that bail amount, she will be required to be supervised by pretrial services, and you must check in with pretrial services within 1 business day of release. I am imposing the condition that you cannot use any controlled substances or alcohol or medication unless you have a valid prescription and be subjected to random drug and alcohol testing. I do find that there's sufficient information based off the allegations. That will be the order of the court, and we'll set a 72-hour hearing, and that will be set for January 23rd. At 9:30 a.m. Thank you.
Thank you.
Next, we have Sean Weeks.
My apologies, Your Honor. Did Ms. Wagner also have a warrant case that we needed to address?
Unfortunately, we are unable to address that here today. I appreciate the parties, and I'll just note for the record that it's my understanding that the parties had all indicated that they would be willing to address it here today, but unfortunately, it is an alternate public defender's office case, and there's no APD present, so it is set for Tuesday. Thank you. I appreciate you mentioning that. No, thank you. Sean Weeks. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found. Just for the make sure it's clear for the record, if there was an issue in this court's Adobe where the pages were not loading properly. So I know that there's information indicating that there was no probable cause. However, given when the court was able to view the correct information, the court did find probable cause and did issue that amended judicial release order. So I just want to make sure that is clear for the record. Probable cause has been found. The public defender's office has been appointed to represent the defendant. I am in receipt of the Nevada pretrial risk assessment, which indicates the defendant scored as an 11 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. In this case, the state is seeking bail in the amount of $2,500 bondable. Pretrial supervision with testing for controlled substances if Mr. Weeks does post that amount. He scores that 11 on the risk assessment, noting 2 points for prior failure to appears. Last year, he was convicted of a petty larceny citation in the Reno Municipal Court. He did fail to appear at his arraignment, which required a bench warrant. He also has the pending case before this court for possession of a stolen property and drug paraphernalia. It looks like that case is also at failure to appear status. Prior to that, in 2024, he had a citation for driving without a valid license, misdemeanor out of Reno Municipal, where he again failed to appear at his arraignment and a bench warrant was issued. In 2023, he had a misdemeanor conviction for removal of a shopping cart, also out of Reno Municipal Court, also with a failure to appear and a bench warrant. In 2021, he had a misdemeanor conviction for contempt and a misdemeanor drug paraphernalia conviction out of this court. And then in 2020, he had a misdemeanor drug paraphernalia conviction out of the Sparks Justice Court. So given that history of failing to appear, significant history of failing to appear, we do believe some monetary bail is appropriate to ensure his attendance at future court hearings. And with the nature of the charges and facts in this case, we do believe supervision with testing to be appropriate.
Thank you. Defense?
Thank you. Given the recitation and the facts as alleged by the state, we believe that they've met their burden under Valdez-Jimenez. However, we would ask this court to consider as an alternative means either interim bail at the amount requested by the state with the ability to readdress should we have a substance abuse evaluation that recommends inpatient and then a direct transport to an inpatient bed, or as an alternative to what the state is requesting at this time. Mr. Weeks indicates that he understands that it might not just be about what's best for the community. It might be a matter of life and death at this point. That is what he is requesting. This court order, he knows that that is the only way that he will get the sobriety that he needs both to pursue this case and to pursue anything else going on in his life. So our request would be either interim and allowing us to get that evaluation, or in the alternative, IAP to inpatient upon the evaluation by a trained SAPTA professional.
Thank you. And it appears that the Public Defender's Office does represent Mr. Weeks in that other matter of RCR 2025-131431. Is there a reason we're not addressing that today? Or are we able to address that OR release here today?
Your Honor, we do represent him. It is my understanding that Mr. Davis represents him, and that was in Second Judicial. Let me check my records. I apologize for my lack of clarity. Court's indulgence, one moment, please.
And I can give you that case number again if you need it.
Yes, please, Your Honor.
RCR 2025-131431. Madam Clerk, I believe that we can't because he's not been arrested on that warrant. Is that correct? Because there was a warrant that was issued.
Judge, he was arrested on the warrant. The reason I did not set it for today is that because I didn't know if the public defender was going to want to figure out negotiations, because he FTA'd for sentencing on that case.
That is correct. He FTA'd, Ms. Doe represents him from our office. He FTA'd for sentencing per our notes on or around July 28th, 2025.
So I didn't know if they were going to want to go forward on sentencing today or what they would want to do.
Thank you. I appreciate that, Madam Clerk.
Your Honor, it's my understanding that sentencing included a matter of restitution, that no restitution documents had been provided by the state to the court at that time, given the requirements under Marcy's law for restitution if there's a named victim. I don't know that I have those restitution documents at this time, and I don't want to stand in violation of that law. I'm happy to set it concurrently or to set it speedily, but I don't want to violate any provisions there, but believe that restitution still needed to be addressed.
That's correct, Your Honor. I think we should just set out sentencing for a separate.
So that's my question of, are you then requesting for him not to be held on that case? Because he will not be held on that case then.
So he was booked on the warrant. So he is booked on the warrant of $5,000. So I can add that today and we can argue the bail on that case if counsel would like me to.
We would submit on the same argument on that, so I believe we can proceed forward at this point.
And Your Honor, given the failure to appear, we believe the $5,000, a 10% cash option to be appropriate, especially now picking up new felony charges with more controlled substances. So we do believe the $5,000 is appropriate in that case, and we would ask that a sentencing hearing date be set if that's appropriate.
Thank you. In RCR 2025-131431, the court does find that the state has met its burden, and with respect to the requirements, an owner cognizance release will be revoked, and I am setting bail in the amount of $5,000, bondable with a 10% cash option. I'm not imposing any conditions at this time, as I will be imposing conditions in the other matter. We will go ahead and set that sentencing. Madam Clerk, is that already set for the 20th?
No, let me get that on and I will get that. I just added it to the calendar, so hold on.
Thank you. It is
Because it
a,
will be,
it would be a Monday, I believe.
yeah, so then we can do sentencing then. Does January 26th work for parties?
Your Honor, just in the abundance of caution, if it's acceptable to the state and the court, I would ask to go out that one more Monday, as there's been recent staffing
Okay.
transitions on our misdemeanor team.
That's fine.
That actually works better for the court. February 2nd then at 9 a.m.
Thank you. And as always, if that needs to be moved, just notify the court. Then with respect to the new matter, the court does find that the state has met its burden by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community and, more importantly, the appearance of the defendant based off of the failure to appears, as well as the likelihood of conviction and the lack of ties. That the court will go ahead and set bail in the amount of $2,500 based off of the request, bondable with a 10% cash option. If the defendant is able to post that bail amount, sir, you will be required to be supervised by pretrial services. So you must check in with pretrial services within 1 business day of release. I am imposing the condition that you cannot use any controlled substances or alcohol or medication unless you have a valid prescription, and be subjected to random drug and alcohol testing. I do find that there's a sufficient nexus based off of the allegations. That will be the order of the court, and in this case, we'll set that 72-hour hearing, which will be set for January 23rd at 9:30 a.m. Thank you.
Thank you.
And may I have that sentencing date one more time? It was February. I didn't catch the date.
February 2nd at 9 a.m.
Thank you.
Thank you. And defense counsel, which of the 2 remaining cases would you like to have heard first?
So Judge, we're gonna need to do Mueller first, per the jail's request.
Thank you. We'll go ahead and call that case, please.
So State of Nevada versus Mason Mueller.
Yes, ma'am.
Good morning, sir. We're here today for a bail hearing. Just for the record, the court is in receipt of the Nevada pretrial risk assessment. And in that case, it indicates that you scored as a low risk utilizing that tool, or a 1. State, please proceed when you're ready.
Thank you, Your Honor. We're requesting bail in the amount of $500,000 bondable, pretrial supervision, house arrest with GPS monitoring, and no contact with the named minor child in this, whose initials are AL. Your Honor, while Mr. Mueller does have a low risk score and has no prior documented criminal history, I would note he does have a carrying a concealed weapon permit. And as the court knows, cases with this set of facts often have no criminal history and a low risk score. However, that does not diminish the risk that Mr. Mueller poses to this community and the children within this community. This was an actual child he was communicating with. It was not only not only the named child victim. However, he was attempting to use that minor victim to recruit her friends to also perform basically prostitution with him, as he was offering to pay the child victims for sexual conduct. Your Honor, given the facts, we do believe that high monetary bail is appropriate in this. We would ask that other conditions include no contact with minor children or places where children frequent.
Court's indulgence, please. Thank you. Thank you, Your Honor. Your Honor, in this case, with the low risk score, the lack of criminal history, we believe that the state has not met its burden to prove that there's nothing, no less restrictive means. There are means. I think it's more difficult when it comes to communication by telephone, but you can have that monitored or reviewed. You can even have sort of no contact except for with policies imposed. We were able to speak with Lori, who is the client's mother, who validated that he has been in Carson for years and at the address, at the same address for years. He's been working for the same company for 5 months. Prior to that, he was an electrical apprentice assistant. He does have a good phone number. He's on track. This court can impose clauses like monitoring, stay away from any and all minors under the age of 18, present phone for review. There's nothing in what the state has said other than the category of the charges, which is significant, but are not, as with an capital or first degree murder charge, no bail charges. A $500,000 bail is essentially a no money detainer. In this case, with that low score of 1, with no prior criminal history, with a validated place to live, employment, and other means available to this court, I don't believe that the state has made the showing simply on the charge alone. This court could have him relinquish if they find a basis, any firearm. I don't believe that basis has been established by the alleged facts in the PC sheet or by any recitation by the state. However, even if that were the case, that would be less restrictive than a permanent injunction on his liberty with that $500,000 amount. With that, I'd submit.
Thank you. I'll just note for the record that with the request with regard to relinquishment of a firearm and search of a phone does not exist at this moment, as we do not have the Department of Alternative Sentencing. I'll just note that for the record. And so with the what is currently available at the disposal of the criminal justice system in Washoe County, the court finds that there are no least restrictive means that can be imposed in order to ensure the safety of the community. I will note the low Nevada pretrial risk assessment of a 1, but with the facts as presented and the factors as outlined in NRS 178.4853 and NRS 178.498 to include the likelihood of conviction, significant threat and harm to the community and specifically the named victim in this case, the state has met its burden and bail will be set in an amount of $300,000 bondable with no 10% cash option. If the defendant is able to post that bail amount, he will be required to have no contact with and I'll apologize, as of right now, sir, you don't have no contact with the minor child with initials AL. You cannot contact or attempt to contact that minor child in any way, including by phone, text, email, electronic means, through social media, or by yourself or through an agent. That means someone working on your behalf. That is effective immediately, just to make sure that is very clear for the record. I will impose the condition that you be required to be subjected to residential confinement where a GPS monitor must be installed prior to release. I do find that that is necessary in order to ensure the safety of the community. Additionally, I am imposing the condition that you are to have no unsupervised contact with minor children, and that is due to community safety. That will be the order of the court, and I will, if I did not say it, you are required to be supervised by pretrial services, and so you must check in with pretrial services within 1 business day of release. We will go ahead and set the 72-hour hearing, and that will be set for January 23rd at 9:30 a.m. Thank you. Next, we have Nathan Peterson.
Your Honor, he waived his personal appearance today. We're prepared to proceed.
Thank you.
I will note that I understand this is an additional booking, that there is an open luring a child or mentally ill person. So we would be prepared to submit to bail as set by the state.
Thank you,
Thank
Your
you.
Honor.
We're here today for a first appearance bail hearing. Probable cause has been found. We will go ahead and waive the defendant's appearance for the record. The defendant has been ordered to be represented by the public defender's office that they've been appointed in this case. I'm in receipt of Nevada pretrial risk assessment, which indicates the defendant scored as a 4 or a low risk utilizing that tool. State, what is your request?
Your Honor, it looks like he does have bail set in the amount of $1 million bondable only on the other, on his underlying case. I'm asking for an additional bail of $250,000 bondable.
Thank you. And defense you submit, correct?
Correct.
Thank you. In this case, I will require, I do find that the state has met its burden based on the facts presented in Nevada pretrial risk assessment and NRS 178. Bail will be set in the amount of $250,000 bondable with no 10% cash option. I do find that that is fair and appropriate given all the facts and circumstances, the likelihood of conviction, and the significant threat and harm to the community. That will be the order of the court, and I will require that all conditions as stated in that other matter apply to this as well. So to include pretrial services supervision, and just to make sure it's clear, I don't have that up in top state. Do you know if he's required to have no contact with unsupervised contact with minor children?
Yes, Your Honor.
Thank you. I just wanted to make sure that was clear.
Yes.
Thank you.
that was
Thank you. That'll be the order of the court, and we'll set a 72-hour hearing, which will be set for January 23rd at 9:30 a.m. Thank you.
Thank you. And Your Honor, I'll go back and look for that administrative order. I'm sorry, on the Cap B and the and the 10%. I'll go figure out what I forgot. Sorry about that.
No need to apologize. I'll just note that it involves a firearm.
Thank you. Thanks, Your
Thank
Honor.
you. Thank you, everyone. Have a great day.
Take care, Judge.
I will put them in your folder. There might just be one.
You are
one
still
that
recording and live.
yeah, let me stop that. Let me